I'm Valerie Dixon. I'm a partner in the Labor and Employment Group here in Vancouver. Today, my co-presenter is going to be Eric Ito. In the room with me right now is Nicole Byers, who's the head of our group here in Vancouver, and also Ashley Mitchell, newly minted partner. So we are going to be talking today about best practices in firing. Now, one of the things that you should know is that we have muted all of the speakers on our audio portion, just so that we don't have any background noise interfering with the presentation. If you do have any questions, though, we do have a chat function on the webinar. You'll see it in the lower right-hand corner of your screen. Please do feel free to type in your questions anytime. We are going to be answering the questions at the end of the session, but feel free to type away. If it looks like we're getting tons and tons of questions, which we hope we do, we'll try and get to all of them, but if we can't get to all of them by the end, you'll have all of our contact information and you can feel free at any time to email any of us to follow up. So we will be making the PowerPoint available after the session via email. There's also going to be a checklist of best practices for termination meetings that we're going to circulate as well. And without further ado, I'm going to turn it over to Eric.
Thanks a lot, Valerie. Thank you everyone for logging in. Let's get started with our presentation today. So as Valerie mentioned, today's topic is going to be about ending employment relationships. And in particular, we're going to talk about this concept of good faith, which really animates the termination process. Over the next 45 minutes or so, we're going to be looking at a number of topics. Firstly, we're going to talk about this obligation of good faith, and we'll unpack what that means in light of a recent court decision by the Supreme Court of Canada. After that, we'll take a look at some of the important considerations that we should keep in mind when we're terminating employees. And we'll take some of those considerations and we'll apply that against a few of the recent cases that we've seen come down in BC. After that, Valerie is going to discuss some of the lessons and best practices that we can discern from those cases and experience in managing terminations. So let's get started. So let's start by talking about the duty of good faith here. In 2014, the Supreme Court of Canada came down with a decision called Basson and Hernu. And the facts in that case are fairly complicated, and I'm not going to go into them in great detail, but essentially what happened there was you had two parties to a contractual relationship who went into business with each other. And as that went on, one of the parties, Mr. Hernu, opened up back channel negotiations and discussions with a third party. And the aim of that was to get this third party to buy out his business partner. And by doing so, that would allow Mr. Hernu to gain a substantial advantage in the market. And the whole time that this was happening, these back channel discussions were taking place, Mr. Hernu proceeded, whenever he was dealing with his business partner, in a very sort of business as usual manner. Nothing strange going on. He certainly never mentioned any of these discussions that he was having with this third party. And to many of us, that probably seems like pretty shrewd practice. But until 2014, from a strictly legal perspective, there wasn't really anything wrong with that kind of behavior. So what the court did in 2014 is it came down with its decision. And one of the things that it said here is that whenever you're in a contractual relationship, you have a general duty of honesty whenever you're performing your obligations. And an important part of that is that you, as one of the contracting parties, must not lie or knowingly mislead each other or the other party about matters which have to do with the performance of your contract or the contract itself. So when you're looking at that fact situation, that's a clear case where there was a duty for Mr. Hernu to be a little bit more open, a little bit more forthright about some of these discussions that he was having, which certainly would impact the arrangement that he had with his business partner. So I will say that with the decision in Basson and Hernu, that was a case that involved a commercial contract. It wasn't an employment case, but certainly employment lawyers like us were watching that case fairly carefully because, well, among other reasons, employment relationships really are at their heart a contractual relationship. And The full impact of that decision really is yet to be seen, and we'll be watching the courts to see how that plays out. But one of the things that we want folks to take away from this presentation is that this duty of good faith is something that's in fact existed in the employment relationship long before the court's decision in Basson and Hernu. And what numerous courts have said throughout Canada, including courts in BC and the Court of Appeal, is that there's an implied term in every employment agreement that the employer is going to act fairly and they'll act in good faith and in the manner in which they carry out terminations. And so that's an implied term in the contract. So what we mean by that is whether you have a contract that's written or not written, or whether you have express provisions or not, every employer, I should say, is under that duty to act fairly and in good faith in the manner of their terminations. So I've cited here a case called Beggs and Westport Foods. That's a Court of Appeal decision from BC in 2011. But as I mentioned, this principle of good faith has existed long before even that date. So let's think about some important considerations that we should all keep in mind when we're terminating an employee. One of the first ones that we should all think about is why is it important to act in good faith and honestly when you're terminating an employee? And one of the things that courts in a number of decisions have come down with and have noted is there's really two elements that are at play whenever you have a termination taking place. The first one is that there's an inherent power imbalance between employees and employers. Generally speaking, it's the employer who has the greater resources and the greater finances. And certainly in the case of a termination, generally speaking, it's the employer who's able to weather that or has less of a detrimental impact than the employee itself. The second factor has to do with the employee's vulnerability during the time of termination and shortly after. In fact, courts have recognized that employees are perhaps their most vulnerable at the time of the termination. And when we talk about vulnerability, we're talking about a number of senses. One would be the psychological impact that a termination would have. For many employees, their job is an essential part of their identity, and the loss of that job comes as a tremendous blow from their own well-being perspective. But the other sense is also, of course, economic vulnerability. Certainly, once you're terminated, that paycheck, which you've come to rely on, is no longer going to be there. So taken together, the courts have noted these two elements and really found that employees in these sort of circumstances require protection at the time of this termination. And so how does that protection actually take place? Well, one of the ways is by requiring employers to, again, treat employees fairly and in good faith when they're dismissing their employees. And we'll talk about what that means, and of course we'll look at some examples as well. Well, what does good faith actually look like in action? Well, we have some indications from various courts, and one of the earliest ones was from the Supreme Court of Canada in 1997 in a case called Wallace and United Grain Growers. And what the court in that decision stated is outlined some bare minimums that employers have to abide by when they're terminating an employee. They have to be, first of all, candid and forthright with their employees. Similarly, they have to be honest and truthful and not misleading. They have to be fair and reasonable with their employees. And perhaps above all, they have to be sensitive to the employee's situation when they're terminating an employee. And in circumstances where an employer fails to do so, when they act in bad faith or they're not honest in the manner of termination, this can give rise to what we call in law aggravated damages. And that's something that applies not just in the employment law context, it's a kind of damages that's at issue in a number of contractual cases. But again, in the employment context, this concept of good faith is so inextricably linked with aggravated damages that many courts have actually started calling them bad faith damages, not aggravated damages, but really just bad faith damages. And the amounts can vary, and we'll take a look at some of the amounts in some other cases. So let's get started, and I'll take a look at some recent cases that have come down in British Columbia. The first one that I'm going to talk about is a case called Davies and Canada Shinneray Suppliers Group Incorporated. That was a decision that came down last year, and it involved a manager at a daycare facility. That manager's name was Ms. Davies, and Ms. Davies was hired by the employer to help manage its daycare facility. And shortly after she was hired, she began starting her job, and one of the things that she did is she brought a number of pieces of equipment and supplies that belonged to her, but she brought that to the daycare facility to help her do her job. And about 1 year into her job, the employer terminated Ms. Davies. And the reasons that the employer gave were all over the map. But at the time of the termination, what it told Ms. Davies was that it was terminating her because she had failed to provide well-organized reports, and secondly, because she had failed to achieve certain sales or revenue targets that caused the employer some loss here. So after that termination, Ms. Davies did what probably many employees do, which is wonder, well, what's next? And so she starts picking up the pieces and moving on. One of the things, of course, she does is she takes those belongings that belong to her, she takes the equipment and she brings it back home. And around that same time, she also sent a letter to the parents, letting them know that she had lost her job and that she was planning to start up a new daycare. Told the parents about that. Now, perhaps not as a surprise, Ms. Davies' sudden termination caused quite a bit of disruption to the daycare. She had these existing relationships with the children that she cared for. She also had relationships with those parents. And the sudden disappearance of Ms. Davies from the daycare was certainly something that caused a bit of a chaotic situation for the employer. And the solution that the employer came up with is really what got it into a fair amount of trouble here. What the employer did is it ended up writing a letter to the parents, and I'm going to read from just parts of what that letter stated, but essentially it stated that on March 31st, there was a chaotic situation due to the sudden resignation of Ms. Davies and the disappearance of our school equipment. And although Ms. Davies was supposed to follow up before her resignation, she left overnight without notifying the company, the parents, and the staff. So clearly that was a lie. Certainly she had left because she was terminated. She didn't resign. And certainly the portion that talked about the school equipment disappearing was misleading at best. That equipment certainly belonged to Ms. Davies and she had just taken it back. So in the wrongful dismissal suit which ensued, the court took a look at that letter and analyzed it from this perspective of this duty of good faith that exists. And what it found was that the employer, in writing this letter, had attempted to shift the blame for this disruption by really stating a lie and saying that Ms. Davies had resigned and implied that she took this equipment. And what this did was it was an attack really on her reputation. And to use the words that I discussed earlier, the manner of that dismissal, the court found, was untruthful, certainly. It was misleading and it was unduly insensitive. And as a result, Ms. Davies incurred a fair amount of mental distress. So aggravated damages were awarded in that case, and in this case it was in the amount of $30,000. I'll take a look at another case. This is a good example of how bad faith can be found to exist in circumstances where an employer fails to carry out an investigation well, or it fails to carry out an investigation at all. And believe it or not, this is a case where an employee was fired over a burger and fries. And the name of this case is Ramen, the Michael Lacombe group. And again, this was from last year in the Supreme Court of BC. So the facts in this case were as follows. Ms. Ramen was a 55-year-old cook. She worked at a Burger King for a period of about 24 years. And during that 24-year period, she had an unblemished service record. And one night, at the end of her shift, Ms. Ramen went to her supervisor and asked if she could take some food home, which the supervisor said, yeah, sure, go ahead, that's fine. And what happened next is really what caused the discrepancy and was what caused a lot of the issues that had to be sorted out by the court. Ms. Ramen ended up taking a burger, some fries, and a drink home. And what the supervisor claimed was that she only gave permission for Ms. Ramen to take a burger, not the fries and the drink. So the issue here was, did Ms. Ramen take the fries and drink? I'll note parenthetically that the court also took a look at that and noted that the cost to the employer for this fries and drink was $1. And when you applied the employee discount, that actually came to 50 cents. So we're talking about something in the amount of 50 cents that was at issue here. The supervisor notified the owner and told her that Ms. Ramen had taken not just the burger, but the fries and the drink. And the owner, very quickly after, immediately terminated Ms. Ramen for cause. It did not conduct any investigation. It certainly didn't ask Ms. Ramen for her version of the events. certainly didn't ask the supervisor to make sure that there was no miscommunication. Hauled Ms. Ramen to the office and said, "You're fired," essentially. So the court took a look at that and again found that the behavior of the owner in that case was unreasonable, it was unfair, and it was unduly insensitive. Again, that language that we see in bad faith cases. And a big part of that finding had to do, as I mentioned, with some major flaws in the investigation that took place. As I mentioned, the owner, when it was first notified by the supervisor, didn't ask any questions whatsoever. Didn't ask to say, well, are you sure you didn't have a miscommunication? Are you sure she had the impression that she could take the fries as well? No questions asked whatsoever. And instead, hauled Ms. Ramen in and terminated her on the spot. And so as a result, Ms. Ramen really didn't have any fair chance to respond to what was going on, didn't have a chance to provide her version of the events. And perhaps equally bad, when the owner hauled Ms. Ramen to the office and fired her, this was in front of other staff. And the court found that this was incredibly insensitive and it opened her up to ridicule. And as a result, Ms. Ramen incurred mental distress and she was awarded $25,000 in aggravated damages, in addition to several other damages that were awarded at trial. Here's another 2017 case. This is a good example of how bad faith can include a lack of transparency. So whether an employer is really being candid and honest with an employee, during the time of termination. So this is a case that involved a day spa. The name of the case is Cottrell and Utopia Day Spas and Salons. And like I said, this was last year in the same court. So in that case, Ms. Cottrell was the plaintiff. She was an employee and she was a skincare therapist and she worked at a spa in Langley for about 11 years. And during this 11-year period, Ms. Cottrell received a few warnings from time to time about her performance, but it was never so serious that she was disciplined. So she never received any written warning letters. She never received any sort of a suspension or anything like that. But after noticing some more recent performance issues, the employer decided to step in and let her know that it had been certainly noticing these performance issues and that she had 3 months to turn things around and to improve and to meet certain specific targets. And if she failed to meet those targets, the employer notified Ms. Cottrell that she would be terminated. And over the next 3 months, Ms. Cottrell ends up working pretty hard and ends up turning things around, and she meets some of these established targets. Her anyways and terminated her for just cause. So again, the court looked at those circumstances, particularly those 3 months that went by, and again found that in this case it had acted in bad faith. And there's a couple facts that it found that backed up its decision or its finding that the employer had acted in bad faith. Perhaps the most obvious one that we can all see here is that the employer promised Ms. Cottrell that if she turned things around and if she improved her performance, she could keep her job. And when she did exactly that, when she met those targets, it terminated her anyways. Another part that the court found was that in this 3-month period, the employer introduced a completely new set of standards that Ms. Cottrell was required to meet. And these standards had never been required of Ms. Cottrell at any time during the time that she had worked for those 11 years. These were completely new standards. And the court found that that was an indication of bad faith as well, that they would introduce what the court saw as somewhat arbitrary targets, which really had no relationship to her job prior to them, and then required her to meet those. And perhaps finally, the court also noted that during this 3-month period, there was a lack of documentary evidence about Ms. Cottrell's performance in that last month. So in the first month, you had metrics and performance targets and sales data, and the second month, the same thing. But the paper trail kind of died off in the third month, and there really wasn't much that you could see for that third month. And what the court found was that it was likely that the employer had decided either then or before the third month to terminate Ms. Cottrell before the 3-month period ended. So in other words, it had made its mind up either in the first or second month or even before that whole 3-month period that it was going to terminate Ms. Cottrell. And so taken together, the court found that, again, the employer had not been transparent in bad faith, and it had awarded aggravated damages, this time in the amount of $15,000. I'm going to cite another case here. This is another example of lack of transparency. And I've cited this case because this is a case where the employer actually wasn't found to have acted in bad faith, although we do have some comments on that. This is a case involving an employee named Deganya. The defendant in this case was the city of Williams Lake, and it was about 3 years ago in the Supreme Court of BC. So what happened in this case is Mr. Deganya, the plaintiff, he was interviewed by the employer and he was offered a position, and he was hired to become its chief administrative officer. And about a week before Mr. Deganya was supposed to start working, the city received an anonymous letter from some individual, and the contents of the letter was harshly critical about Mr. Deganya himself and his performance in his previous job. And the employer looked at that letter, it circulated it among the council members, and together they came up with a decision that it would terminate, or it would rescind its offer of employment to Mr. Deganya. And that's exactly what it did. It contacted Mr. Deganya and let him know that the employer had changed its mind and it wasn't going to be hiring him after all. And during these discussions, at no point did the city tell Mr. Deganya that part of its decision was based on this anonymous letter that it had received. So in the ensuing wrongful dismissal action, the court had to deal with a number of issues. The first one that it dealt with was whether it had in fact terminated Mr. Deganya. One of the things the employer argued was that, well, he actually hadn't even started working yet, so we hadn't terminated him. But the court pretty quickly decided that it had. To Mr. Deganya, he had accepted that offer, and simply because he hadn't started working yet doesn't mean that this employment contract was formed and that it was breached when it rescinded it. When it came to the actual manner of the termination, the court found that in this case the city had not acted in bad faith. It certainly should have told Mr. Deganya about that anonymous letter, but the failure to do so in the court's view said that that conduct approached but didn't actually reach the threshold of conduct needed for bad faith. And so that's an example where a court found that bad faith didn't exist, but in my view at least, I think that had it been a different court at a different time, there's a really good chance that that bad faith would have been found. So I certainly wouldn't take this as any sort of example of conduct that an employer should follow in those sort of circumstances. Here's another element of bad faith, or something that courts have examined. One question that's come up in a number of cases is whether an employer's refusal to provide a reference letter constitutes bad faith. And I've selected two cases, and there's a bit of they're similar in some respects, but they also diverge in others, and so I'll explain what I mean by that. The first case here is one called Nicholson and Masonite International Corporation. That's from about 4 years ago. Again, it's a British Columbia case. The facts there are fairly straightforward. Mr. Nicholson was a 45-year-old chartered accountant, and he worked for the defendant. He acted as its controller. About 2.5 years into his employment, the defendant employer terminated Mr. Nicholson, and after that termination, Mr. Nicholson began a wrongful dismissal suit against the employer. And as that dismissal suit was working its way through the court, Mr. Nicholson was certainly looking for a new job. And during his job search, a former colleague of his had acted as a reference, and Mr. Nicholson had used him as a reference. And Mr. Nicholson contacted that person and asked whether he would be prepared to provide a reference letter to him, to a prospective employer. And that colleague actually refused to provide that reference letter. And the reason why the colleague refused to do so was because there was this ongoing lawsuit that was taking place, and it wouldn't be proper in that person's view to offer a reference letter. So when the case finally got to trial, one of the things which Mr. Nicholson argued was that the defendant's refusal to provide a reference letter was an example of bad faith. Or alternatively, even if it wasn't a bad faith, it's something that the court should be mindful of when it's thinking about the amount of notice or severance that he was entitled to. And the court looked at that from both lenses, both from a bad faith perspective, but also from a reasonable notice perspective, and found that in these sort of circumstances, an employer's refusal to provide a reference letter isn't a factor in determining severance, nor is it an example of bad faith. So that's one thing that the British Columbia court had decided. But I'm going to compare this to another case that came out in 2017 in Ontario, because in very similar circumstances, the court agreed with the court in Nicholson that the refusal to provide a reference letter doesn't constitute bad faith, but what it did do is it took a look at that and determined that that was a factor when considering severance there. So I've gone through a number of cases, and hopefully we can see through that there's a few lessons to be learned, and there's some pretty obvious ones, but there's also some pretty subtle ones as well. And what we'd like to do at this point is really apply that in a best practices perspective. And what Valerie's going to do is she's going to provide some tips and tricks and some best practices that we can all bear in mind when we're looking to discharge that duty of good faith. So on that note, I'm going to turn things over to Valerie.
Thanks, Eric. I think if I was going to retitle this portion of the presentation, it would probably be "Take a Deep Breath," because that's the most important thing that you can do before deciding to actually proceed with the termination. So I'm going to talk about 3 issues. One is making good decisions. The second is managing risk that comes along with the decision to terminate. And 3, I'm going to touch briefly on proper communication of the decision. Like I said, we're going to be sending out a memo which sets out some best practices for termination meetings. I'm not going to cover really any of what is in that checklist, but I think you will find it pretty helpful if you have to actually do one of these termination meetings. Hopefully not anytime too soon. So this is where the deep breath comes in. In order to have a successful termination, in my mind, you have to have first made a good decision about the termination. And that requires you to make a decision that is not clouded by anger and frustration. Believe me, we get it. Employees can drive you absolutely crazy, and certainly when you put your heart and soul into your business, as I know that so many of you do, when you have somebody who is a problem in the work environment and is dragging everybody else down, your instinct is to just get rid of them. What I encourage you to do is to just step back, like I said, take a deep breath, and think about how you want to deal with this in the most constructive way. And that's, that's going to be the case in terms of whether or not you're deciding whether you need to terminate the person at all, whether you're going to terminate them with or without cause. Perhaps there has been a very heated meeting and the employee has thrown their pencil down on the desk and stormed out, saying, "I quit." Again, take a deep breath. Hopefully give one of us a call and decide what the best course of action is, because that moment when you do take that deep breath is the moment where you may decide to take a path that is going to mitigate your risk as opposed to aggravate your risk and end up in the sorts of situations that Eric was just talking about. So often what can happen, particularly if you're an organization that has a board and there's a number of people involved in the decision-making process, is you can get into a groupthink type of situation. There may be a lot of information floating around. It hasn't been verified. There have been rumors. And you need to, first of all, make sure that you're dealing with all of the appropriate information and that you're making a decision based on a complete picture as opposed to a lot of people's emotions, opinions, or something that has happened on a spur of the moment. So at the end of the day, I mean, it may be that it is the right thing for an employee to be terminated, and that's most often a business decision. But what all we're saying is it's best to take the time to make a decision rather than jumping to conclusions and just trying to exit somebody out of the business as quickly as you can. Developing that strategy in order to minimize your risks, both legal and business, because they are quite separate sometimes, is going to be your best approach. So I know a lot of you have come to some of our other seminars, and we have talked about investigations previously. I'm not going to go into the details of what a proper investigation looks like, but certainly in most cases I would say that an investigation, particularly if there is any allegation of misconduct, or even if there's allegation simply of poor performance, you need to make sure that you have all of the relevant facts available to you before you make your final decision. And that is most often, or I would say in every case, going to involve meeting with the employee to obtain their perspective of the situation. It's not always going to be necessary. I mean, sometimes, for example, if you are just making a decision to terminate an employee without cause, and it's just based on a pure business decision that doesn't really have anything to do with them, then that's not probably going to be necessary. But if you're terminating them because of something that they have or haven't done, then even if, this is my view, even if you are going to terminate them without cause, because of the transparency issues that Eric talked about, I think it's still a best practice to meet with the employee and obtain their perspective and their version of the events or the conduct that has led you to feel that a termination may be what you need to do in the circumstances. Again, if we're talking about misconduct or even poor performance, you do also need to consider the fact whether or not there has been similar conduct by this person or others in the workplace that was previously condoned, or if there might be some other reason why this person has engaged in this conduct that might explain why they are. And so again, this is another reason why meeting with the employee in advance of a decision being made is going to be absolutely integral to the process and to ensure that you're making a good decision. We always do, of course, like to recommend that you obtain legal advice to confirm and provide you with some analysis of whether or not there is sufficient evidence to support a termination for just cause. Again, I'm not going to get into the details of what just cause is, but you can just know this. It's very difficult to meet the threshold required for just cause. And I know that is a very frustrating thing for employers to hear, because from their perspective, if somebody is not doing what they're supposed to do, then they should be able to just terminate them and they shouldn't have to pay them any money. But unfortunately, our courts don't see it that way. And so there is a significant risk associated with terminating an employee for just cause. Also, of course, because of the reasons like Eric talked about, where you're alleging just cause, if you haven't done a proper investigation, you haven't obtained all the facts, making those allegations can result in an award of aggravated damages on top of course, the reasonable notice or contractual notice that an employee may be entitled to. So that's also part of the process of identifying all the potential risks associated with both the termination, but I'm going to talk about a little bit identifying the potential risks of not terminating as well. So after this slide, I'm going to get into risks associated with human rights complaints and also associated with protection of business assets. But starting more basically, you want to think about, okay, if this person is terminated, if there isn't just cause for termination, what is the severance obligation going to be? What is the price of this termination if we're wrong about just cause? And again, there is a significant risk that you may not be able to reach that just cause threshold. So that means digging out your employment contracts. Hopefully you have them. If you don't, we can help you with that. But getting out the employment contract to see if the employee has a termination clause in their employment contract, making sure that the contract, of course, is enforceable and that the termination clause is enforceable, because there are some very technical issues associated with enforceability of employment contracts and termination clauses in particular. So that is one thing that you really need to consider, because sometimes if you've got a great employment contract and it's got a very favorable termination clause in it, sometimes it might be easier and potentially cheaper to terminate somebody without cause as opposed to cause because of the potential risk associated with terminating for cause if you can't establish cause. Now, I want to mention one issue that has been coming up in the cases recently, and that is the issue of whether or not somebody terminated with cause is limited. If they go to court and they bring a wrongful dismissal action, they go to court and they end up with a decision that says the employer did not have just cause to terminate, is the employee limited in their damages for severance to what is in the employment contract that they had, or are they entitled instead to reasonable notice at common law? And there is some inconsistency and lack of clarity in the case law. And from my perspective, I think it is more conservative to assume that an employee who is successful in challenging an employer's allegation of just cause, that employee may well receive a judgment that is not limited to what is in their employment contract. Although there are some cases recently where, and one of them is that Cottrell case that Eric was just talking about, where the court actually limited the employee's entitlement to damages to what was in the employment contract, even though the employer had alleged cause and had failed to actually establish just cause in front of the court. So there's some lack of clarity right now in the case law, but again, my conservative approach and advice is don't assume that that is always going to be the case. And so if you're considering what the risk is, what the potential price tag of a termination is, I would always be looking at what would reasonable notice be for this particular employee, even if they do have an employment contract. I made a reference to the risks associated with not terminating. There are, of course, significant risks associated with not terminating certain employees. If you have an employee who is creating an absolutely toxic work environment, they may be bringing down your business, and it may be that they simply have to go. And that is a business decision. That is something that needs to be taken into consideration, because it's incredible, I think, the impact that a bad apple can have. And of course, you also have to remember that you as an employer have certain obligations with respect to ensuring that your workplace is free of bullying and harassment, and ensuring that your other employees are protected and well taken care of. So again, all considerations to be looked at in making this very well thought out decision after you take your deep breath. So one of the most significant risks associated with terminations, of course, is the potential for human rights complaints. Many employers have had to deal with these. And you have to first consider whether or not the employee that you may wish to terminate falls into a protected class, and such that they might be able to allege that the termination is somehow connected to that prohibited ground. Is there a nexus? And you're going to protect yourself from that by making sure that you have documented that there isn't a nexus between the protected ground and the termination. And sometimes the fact is that there may be very little way to completely avoid the unfortunately, we do see many meritless human rights complaints proceeding. Some of them get dismissed on a preliminary basis, but the Human Rights Tribunal still appears to accept most complaints that are filed unless they are completely off the wall or there is some sort of limitation issue. And so it may be that no matter what you do, there's going to be a risk that an employee is going to think that there is that nexus between their age or their disability and the termination of their employment. And this is why, from my perspective, even when you're not terminating for cause, there can sometimes be a very important role in providing a detailed letter setting out the reasons for termination. Even if you're not saying, we say that this is cause for termination, you still may need to explain exactly why the decision has been made to terminate their employment. And they may not fully accept that. I mean, they may simply be totally convinced that the reason that they're being terminated is because they're 65 years old. But at the bare minimum, what I think it does is it provides them at least with some food for thought. And if they go to a lawyer, it may provide that lawyer with a bit of a pause as to whether or not this person may have a potential human rights complaint, and they may be less likely to want to take that fight on if the employer has broken down, in relatively good detail why the decision to terminate has been made. In terms of protection of business assets, this is particularly important when you're dealing with somebody who is really integral to your business. And, employees, of course, are the lifeblood of most businesses. They have sometimes a huge amount of value, and they sometimes have a huge amount of knowledge. And so before you make that decision to terminate, you've got to decide, how are we going to protect the things that this employee has in his or her possession, mind, that may actually have a negative impact on the business if they leave. So that's going to be looking at, how do we mitigate the potential for loss of confidential information, skill set, experience, relationships with customers, the reputation of the business. All these things have to be taken into consideration, and you have to come up with a plan as to how you're going to transfer or transition that information and skill set and those relationships to other people within the organization, so that you don't lose that value that has been built up in this particular employee. There's also, protection of business assets can also be simply financial. Of course, employees are less likely to make claims if they can get a new job relatively quickly. And so sometimes that's, the reference letter that Eric was talking about. But it can be anything else that the employer can provide in order to assist the employee in transitioning to new employment. And it's incredible, actually, how that can really pay for itself in the long run. And these are things like working notice. Sometimes, I think we've talked about working notice in the past, but And that it's not always an option, for sure. But if it is an option, it should be considered because it can certainly reduce your severance liability significantly. And then, of course, there's things like employment counseling or placement services, which don't necessarily come at a very big cost, but can be very useful for an employee, particularly somebody who's been out of the job search market for a long time and may not even understand how to look for a new job anymore. That sort of service can be really valuable to them and can make things a lot easier. And I think, again, this is the deep breath is, you know, sometimes in order to mitigate your risk, you may have to put off the decision, right? Or you may have to put off the effective date of the decision because you need to take certain steps and put certain things into place to ensure that you are protecting your business assets. Again, I can tell you very, very clearly that rash decisions and decisions that are made quickly without considering the sorts of things that that I'm talking about today, they are always going to mean that this is going to be a more expensive process, and it has to be. And it may seem at the time like it's so important that this person get out of the organization quickly, but more often than not, you're far better off taking the time to make a good decision and put in these plans. So again, I'm not going to talk too much about actually how to communicate the decision because we are running a little bit short on time, but I think it goes without saying, and this is not rocket science by any means, but treating people with respect and dignity is always going to help you in the long run. Making sure that the termination meeting is carried out in a respectful and dignified way in a place where the employee has privacy, feels like they're not being watched by other people in the workplace. That is going to go a long way into their overall perception of how the termination goes down. You know, I've said here to do the interview in a location that ensures privacy, but also, I mean, take into account that there may be some places where it's not appropriate to do a termination meeting. We were not laughing the other day, but we were talking the other day about a very well-intentioned employer who decided that perhaps the best place for a termination meeting was a hotel room, which was not appropriate in the circumstances. So, and again, they were just trying to ensure privacy for the employee, but a hotel room was clearly not the place for that particular sort of meeting. So give that some thought. And of course, you know, you've got the rest of the workforce to think about as well, because the way that an employee is terminated, particularly, I mean, if they're well liked, is going to have a big impact on the perspective of the people that are left behind. So you want, you know, all of your communications are going to reflect your company values, and understand, of course, that it is going to be unsettling for the other people in the workplace, whether or not this person was liked or not, frankly. And you need to understand that and to make sure that you know, the communications that you're providing are going to be informative enough, but also protecting the privacy of the person who's been terminated. You know, there may be in certain circumstances a need for a communication which censures certain behavior that may have been the basis for the termination. And there are ways to do that, though, where you're not personally attacking the individual who has been terminated. You can make it about the behavior as opposed to the individual. Sometimes the best way simply to address it is through further training, right? I mean, most people are probably, you know, may know, well, this, you know, so-and-so was a bully, And I wonder why we're now getting bullying and harassment training again. But the point is that you are sending some sort of a message to the rest of the workforce that that particular behavior, while not directly attributed to any particular person, is still something that isn't tolerated in the workplace. And as always, you have to be looking down the road to what these communications could be used for in future. And I mean, as you will have seen from the cases that Eric talked about, sometimes letters, messages can be brought out as evidence at trial, and so you have to make sure that you're not providing a communication that is ultimately going to harm you in the end, and support a claim for aggravated damages. So we've come to the end of our presentation, and if anyone has any questions, I don't think that I have seen any questions coming up on the chat, but maybe I'll just give one more moment to see if anybody has any more questions. I do have a compliment. That's very nice. The questions really are. Okay, so, there's a question. Will the deck be shared with the participants? Yes, absolutely. You are going to be getting an email with all of the PowerPoint slides, as well as the best practices checklist, and that's going to be coming out, I think, later today. Okay, well, given that I'm not seeing any other questions, I want to thank you all so much for coming to our first webinar. We're really hoping to do at least a few more of these this year. We think it's a really great format because, of course, it allows all of you to come and join us without having to leave your offices. But we do also hope to put on an in-person seminar later this year because we like seeing you all as well. So from Eric and me, come on in here, Eric. Thank you so much for joining us. Please do let us know if you have any questions. Feel free to email